So hi, JJ Gatt. So I'm going to do a quick little recap on what the U.S. Supreme Court decided in the Moody versus NetChoice case this week impacting social media platforms. So if you're interested in that, stay tuned. Hi, this is JJ Gatt. So on this account, I help fellow content creators decode the laws related to the creator economy and social media generally. Really quickly, in this video, I'm going to go through what the U.S. Supreme Court is. What do they do all year? What's this case about? To what was the final decision, and then finally, what does it mean going forward for social media platforms and all the parties involved, including the states who are integral to this decision. So U.S., we have three levels of government: local, states, and federal. And then the federal, which is the highest level, there's three branches: the judiciary, the people who interpret the laws that are passed by the legislatures, which is the Congress. There's another body called the executive, which is the president and his agencies that execute the laws that Congress passes. What they do, the Supreme Court, all year is early on, they decide who should come up, which cases they should hear. So there's two ways you can get a case before the Supreme Court. The first way, and the most common way, is through an appeal from the federal circuits or the district circuit, or if the state passes a law and the highest state of land passes a law and someone says that state law is unconstitutional. That's the usual way, is through appeals. And then there's the other way, which the Supreme Court is original jurisdiction. That's when there's disputes with treaties, with ambassadors, disputes between states. Maybe someone's trying to get a stay of execution. Those are rare ways that Supreme Court hear decisions. But irrespective, the Supreme Court has to make a decision on what cases they hear. They don't hear everything. They need at least 4 justices to agree to hear cases. So that's what they do early on in their term, which starts around September. Then after that, all of the cases that they had decided we're going to hear them, they start hearing those cases. They have the oral arguments. That's through fall, through winter, and around the springtime, around now, they start actually issuing the decisions. So the way the decisions go on, there's 9 justices. If you have 5 on one side and 4 on the other side, that's the rule of the land. You can have unanimous, where everyone agrees on something, or you can have a majority rule. It's different, a split. And so usually there's one justice that writes the opinion for the majority side, the winning side. Whether it's unanimous, whether it's majority, there's one justice. And the other justice, they say, I agree with it, but I have something extra to say. Those are called concurrent opinions. And then you have the losing side. So let's say it's a 5-4 split. 5 justices approve a law, 4 are against it. You can have a justice that say, I'm going to write opinion on behalf of us dissenting ones. And they could join or they can make their own. So in this case, the states of Florida and Texas issued laws because they were concerned the way the past president, for example, was removed from one of the social media platforms, X. And they also were concerned that folks who represent their voices, the conservative voices, in their opinion of the states, being targeted or violating the guidelines or rules. And the platforms determined that what those people were saying wasn't necessarily within the policy guidelines, and so they had them suspended. And so in interest of those voices, diversity of voices from the right side, the states of Florida and state of Texas decided to issue laws and pass them saying that social media platforms, they have to allow all voices to come through irrespective of that, and essentially say they're not allowed to have content moderation. So NetChoice, which is a trade organization, its members includes X, Meta, which is the parent company of Facebook, Instagram, and WhatsApp, and then Alphabet, which is a parent company of Google, which owns YouTube, and then Snap, and all the various different trade organizations. NetChoice sued, and it came through the different circuits. And there's a split. Again, remember I said how cases go to the Supreme Court if there's a split in circuit. So the 5th Circuit, which includes Texas, decided that states have a right to be interested in the diversity of voices, and that's okay. And the law didn't go too far. Then you have another circuit, which said, the district court, which said, no, actually, this is clear on its face violation of the First Amendment rights of the social media platforms, which are entities, but they're also private, and they have the right, just like newspapers, to say what they can and cannot say. So with that split of circuit, it percolated itself, and the Supreme Court decided we're going to take that case. There were oral arguments held in the winter, and the decision was 9-0 to send it back down to the states, but they also agree the social media platforms are similar to newspapers like the Miami Herald, the LA Times, USA Today, New York Times, CNNs, that they are entitled to First Amendment protections. They did not agree to what extent the states could or could not actually have something to say about the way they content moderate. Justice Kagan wrote the opinion, and they all agreed on just that one part. So the other 3 justices that agree with Elaine Kagan were Justice Sotomayor, Chief Justice Roberts, and also Justice Amy Coney Barrett joined in with Elena Court on the entire decision. Amy Coney Barrett made her own concurrent opinion, meaning extra opinion, saying that in addition to what Elena Kagan wrote in her opinion for the court, she also said that it's not fleshed out, that she felt like this area was so new and so nascent that it needs to be developed more. Brown Jackson issued her own opinion concurring. She said she agreed with parts 1 through 3. She didn't agree with the part where Elena Kagan said it's clear that there was a violation. She said it's not clear. Justice Ketanji Brown Jackson said it is not actually clear that there was a violation, that it still needed to be fleshed out furthermore. So she didn't agree with that part. Justice Thomas wrote his own concurrent opinion saying that he is concerned that there was not much weight given or consideration given in the lower courts to the fact that states do have an interest in making sure there's a diversity of voices. And with those interests, that should have been addressed. And that when they send it back down to district courts, that's something he wants to see the courts address and analyze. And then finally, Justice Alito wrote an opinion on which Justice Gorsuch and Justice Thomas joined. In his opinion, he said, in addition to what Thomas said about the states having some interest, he also said he was concerned that social media platforms may actually use First Amendment as a way to target certain voices. And so he went a little bit further there, and Thomas joined in with that in his concurrent opinion. So that's how it fleshed out. So what does it mean? This means that social media platforms indeed enjoy the rights, and so that's what it says. It's going to go back down. They're going to flesh out the issues some more. So I hope that's helpful for you. You have any other questions, ask below. And if you're interested in any other videos I've done interpreting laws related to content creators, the creator economy, I'm going to invite you to watch a playlist here.